I'm Michael Hackard with Hackard Law. If you've created a living trust, or you're planning to, it's probably because you want to avoid conflict. You want to keep your loved ones out of court, out of probate, and out of long, expensive family battles. But here's the truth most people don't hear. Even a living trust can lead to litigation. At Hackard Law, we've handled hundreds of California trust disputes, and time again, we see families fighting, not because they're greedy, but because the trust had gaps that created confusion, suspicion, or misunderstanding. And that's what sends people to court. Let's talk about those gaps, what they are, how they happen, and how you can avoid them. One, the trust was never funded. This is the number one mistake. You created a trust, but you didn't transfer your assets into it. That means homes, bank accounts, and investments are still in your personal name and still have to go through probate. That mistake alone can cost your family time, money, and peace. Two, the trust is outdated or vague. Maybe it was written years ago, before a divorce, before grandkids, before new laws. Or maybe the language is so broad that no one knows what divide equally really means, especially in a blended family. Vague trusts are like ticking time bombs. One wrong interpretation and someone's headed to court. Three, the wrong trustee is in charge. A trustee isn't just a title, it's a responsibility. If your chosen trustee is biased, disorganized, or over their head, it can lead to lawsuits, delays, and even asset loss. We've had to petition courts to remove trustees who mishandled everything from accounting to family dynamics. Four, stepchildren are excluded, even when that wasn't the intent. If you don't legally adopt your stepchildren or name them specifically in the trust, California law may exclude them. That leads to painful courtroom fights between spouses, children, and stepchildren. If your family is blended, your trust must be crystal clear. Five, there's no incapacity plan. A trust helps when you pass away. But what if you're alive and incapacitated? Without a power of attorney and healthcare directive, your family may need a conservatorship just to help you. That's another trip to court, and it's completely avoidable. Six, personal items are ignored. We've seen major court fights over watches, paintings, and old family heirlooms. It's not always about the money. Sentimental items matter, and when your trust says nothing about them, people argue. A simple personal property memo can make all the difference. Seven, the family was never told. You may have a great trust, but if no one knows your plan, misunderstandings are guaranteed. Surprises cause suspicion, and suspicion breeds litigation. At Hackard Law, we've seen how silence fuels conflict, and how even the best intentions get twisted when emotions are high. So, how do you avoid all this? Fund your trust, update it every 3 to 5 years or after major life events. Be specific, especially with beneficiaries and gifts. Choose a responsible trustee or consider a professional. Include powers of attorney and incapacity planning. Communicate your plan, at least with key family members. A living trust should bring peace, not provoke conflict. But that only happens if it's built and maintained with care, clarity, and foresight. If you're unsure whether your trust is truly solid, or if your family's already facing disputes, Hackard Law can help. We handle trust litigation across California, and we know how to spot the gaps and how to fix them. I'm Michael Hackard. Thanks for watching, and remember, your legacy deserves to be protected. Contact us today for a confidential consultation.